Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Jennifer Cunneen. Jennifer is an attorney with the law firm of Hopkins and Carley in San Jose. She began in the law practice in 1989 after graduating from Santa Clara University Law School, cum laude.
Broncos.
She has an AV rating, which is the highest rating for attorneys in both practice and ethics. Jennifer's practice areas include estate planning, probate, special needs trusts, tax planning, and charitable foundations. She also works with many closely held and family businesses to plan their succession. She is married to former state assemblyman Jim Cunneen, that's where the Cunneen comes from, and they live in San Jose with their 2 children. And Jennifer is a newly minted member of the San Jose Rotary. Congratulations.
Thank you, Michael.
And in her spare time enjoys reading, movies, and travel. And today Jennifer and I are going to be talking about whether a family trust should be terminated considering the tax law changes in the fiscal cliff tax legislation passed January 1st, 2013, also called the American Taxpayer Relief Act of 2012, and its impact on estate planning. So there were some major changes in that act that we're going to be talking about, and it's causing a lot of people to re-examine their trust planning. Now, as we get started, I'm going to caution our viewers that this is only an introduction to complex issues, to help become aware of them for a further discussion with an attorney and or another tax advisor who's familiar with them. And the problems that we're discussing are complex, and there may not even be solutions to some of those yet. Jennifer, thanks for joining me today.
Well, thanks for having me.
All right. So, Jennifer, why don't we just go through some highlights of some of those changes in that fiscal cliff tax legislation. It may be a little fuzzy in some people's minds now. Almost 2 years ago that this happened. So they, is this the current development? Well, it's fairly current in the history of the tax law. So why don't we just sort of do a little quick survey of some of those things.
It is still fairly current, and because there have been some significant changes to the way the law works, I think a lot of people are still struggling with what are the right solutions for families in terms of their trusts. And so the first thing I'd say is for folks out there who already have what's called a revocable living trust, which is just an estate plan you put together while you're living that can hold your assets. If you're thinking of running out and getting rid of it, I would probably caution you not to rush out and do that without consulting with a lot of folks, because really in California, one of the main reasons for trusts is not just tax driven, it's also to avoid probate on death. So by keeping your revocable living trust in place, especially if you own real estate, large amounts of assets, it's going to really come in handy and be beneficial for the family in the future. The real question becomes now, what kind of trust do people, really need? And there are a lot of different solutions for those trusts and a lot of different types of trusts out there that are all revocable living trusts. And so the way that they're set up is really going to depend on personal situations, wealth, whether it's a first marriage or a second marriage with children from previous marriages. There's all kinds of factors to take into consideration when setting up a trust. Really beyond the scope of today. But I think the main issues for people to realize is that everyone, I think, out there, and many people are probably still under the impression that the death tax exemption, which for many years was $600,000 and was locked there, and then it rose to $1 million, has now increased dramatically on a permanent basis. And when legislation that Michael mentioned went through, it was raised permanently to $5 million plus an index for inflation. So this year, the exemption from death taxes and gift taxes is $5.34 million per person, which means it's $10.68 million per couple.
Okay, now, just to let people know, we're recording this on November 4th. 2014. You're probably going to be seeing it next year. So also then why don't you remind people what's going to be the exemption for 2015?
The exemption for next year has been announced. It will be 5.43 million. So
Okay.
then again, for a couple, then 10.86 million, which even in California covers, the vast majority of couples.
Yes.
And the tax over and above that is a flat 40%. So for those families fortunate enough to be in that position where they're, up around the 10 million plus mark, you definitely want to consider, that 40% tax rate, and whether there should be things done in your trust planning to try, or gift planning to try to, alleviate any tax burden there.
Okay.
So.
And, okay, so this exclusion that we're talking about, it applies for the federal estate tax and the federal generation skipping tax and the federal gift tax. So it's
Right.
again, sort of a unified exemption.
Yes.
As we did at one time. And then for a little while we had, a difference between the gift tax and the estate tax. But now
Yeah.
we're on the same page
We're
as far as
on the same page, which is great for planning, because traditionally back in the past, even in 2010 when the federal exemption for estate taxes was repealed, there was still a gift tax. And so we were very lopsided, that year. And now Congress has said, hey, even though we're going to raise the estate tax exemption to over 5 million, they could have left the gift exemption a lot lower, and I'm sure considered doing that, because the idea is always been, as far as we know, with Congress, to try to push out the ability to transfer wealth. But having the ability to either use that exemption during lifetime or at death is a nice planning vehicle for families. And there are a lot of families that really would like to give some things earlier to their children to help them, because the cost of living is so expensive, for kids starting out these days.
That's right.
So.
Why don't you also talk about portability for a moment?
So portability is really a very brand new concept that's really never been in the tax law before the past few years. And so portability says that if you have a husband and wife and one of them dies first, but they don't use up their entire $5.43 million exemption, now the surviving spouse, if they make a proper election on an estate tax return that is timely filed within 9 months, usually of the decedent's death. There's a way to extend that, but you have to file something within 9 months of death. The surviving spouse can elect to take whatever exemption wasn't used and pull it onto their return. So for example, if the surviving spouse happens to have a lot of separate property in California, inherits money later, has an estate that really grows in value, that spouse is going to be able to actually use a cumulative, double exemption. So that helps the family as well. And it alleviates the situation which used to happen where, depending on which spouse died first, if one of the spouses had a lot of separate property that they inherited from their own families, it could cause a different tax effect based on who died first. So we've
Right.
gotten rid of that, which is wonderful.
Right. So this is a really huge change. It was sort of put out there on a tentative basis a couple of years before,
Right.
but it was made permanent in this fiscal cliff legislation. The other thing is that folks need to know, and we're not going to get into depth on this thing today, but I think I've done a whole other program you might be able to find on portability. I think maybe even with Jim Cohen. But anyway, the exemption, if you will, the inherited exemption that wasn't used by the first deceased spouse, that does not index for inflation.
That's correct. So whenever year the deceased first spouse to dies, and let's say it is 2015 and the exemption is 5.43 million, if that deceased spouse, say, has given gifts to children and things of 4 million, and there's 1.43 million left, that's all the surviving spouse can take. And actually, once the surviving spouse starts making gifts, they're going to actually use up that exemption first. So,
Right.
Yeah.
And the other thing related to that, if I don't lose it in my head, is that it doesn't apply for the generation skipping tax. So we have portability for the estate and gift tax exclusion, but it does not apply for generation skipping. And so again, this is a valuable thing to consider when we're talking about trust planning, and we're
Right.
setting up trusts for grandchildren and so forth.
So you definitely want to talk to the family, find out what their goals are, if they're trying to pass, assets to children, to grandchildren, and then see how the best ways to structure to hopefully help minimize taxes, because there's nothing wrong with minimizing taxes as long as the IRS and the Internal Revenue Code allow it. So we try to help folks. I think both you and I try to help folks, work within the laws to minimize taxes when they can.
Let's talk a little bit about income taxes. And again, we're not going to beat this to death, but just some highlights, because we've had some pretty significant changes that happened in this legislation.
Yeah, so another thing I should mention up front, has to do with basis too. So that's an income tax issue.
Yes.
And so when someone dies, the property that they own in their estate gets a adjustment to basis. It's a step up in basis to fair market value, or a step down, actually.
So
it goes both ways.
Just to help our viewers again, so when we say basis, which is a term of art for a tax person, what we're talking about is what you use as the cost when you sell an item on your tax return. So on your Schedule D, you'll have a basis number, but it may not be what the original cost was. And a lot of families are very confused about this because they don't know. They're not trained as tax practitioners. And so they may sell the family home after Dad dies, and in fact, there may be an adjustment that's supposed to be made to the tax basis to the fair market value at the date of the death. And how those rules work vary a little bit depending on how the title is held and so forth. But anyway, so there may not be very much or any gain to report related to that sale of the home.
Right. It's like
okay.
it's like for a house, and Mom and Dad bought that for $200,000 several years ago, and when the first spouse dies, we'll say that's Dad, the house is appreciated to $600,000. Then that's the new tax basis that Mom gets to take on his death. And in a trust, that's okay in a trust as well. Their revocable living trust, Mom probably gets that step up in basis. Like you said, Michael, it could be, depending on how they held title, there might be some adjustment to that, but community property for certain gets that step up in basis. When Mom dies, if she has that property held in her estate, in her side of the trust, or in her trust, or just in her name, that gets a step up again for the children. So if it rises to another $200,000 or $300,000 by her death, the children would be able to sell that house without any capital gains tax, even though they don't use the house as their principal residence. So it's a really helpful law. And one of the things to consider on these trusts then is when the trust is set up. And a lot of people have set up trusts over many years, and it's been the standard of the practice as either what's called an AB trust or an ABC trust. And I think a lot of people have probably read about those terms and may not really understand what they are. But essentially, in sort of a simplistic version, in California with community property laws, for example, if all the assets are community property, Mom and Dad each own 50%. So when Dad dies, if you set up a traditional AB trust, Dad's half of the assets go into what's usually called a bypass trust or a family trust. And that trust becomes irrevocable at Dad's death, generally. Mom's assets stay in what's called usually a survivor's trust. And that stays completely revocable and is in her estate for death tax purposes. That bypass trust, the issue with that is if the assets go there, they're probably exempt from death taxes. But on Mom's death, they're not includable in her estate, so the kids don't get that step up in basis. So that's what everyone's talking about now. With this huge, really very large 10 million plus exemption from death taxes, we're not so worried anymore because of portability and things and the large exemption about keeping those assets out of Mom's estate as the survivor. We're more worried about getting basis step-up adjustments and making sure assets, go where they need to go. So that's I think the main question here is, do we take that bypass trust and do we try to terminate that to pull the assets into Mom's estate so they'll get the new basis step up, especially if there's quite a few years of gap between mom's and dad's deaths. It could be really helpful to the family.
Right.
So
And there's also some income tax issues I wanted to talk about just briefly.
that's true. Yeah.
So we've got an increase in tax rates that's particularly significant for trusts.
Mm-hmm.
When you compare it, to what you would have for individuals. Maybe you could talk a little bit about that.
Sure. So trusts, if it's an irrevocable trust, meaning the trust can't be changed anymore, then the trusts typically pay income tax if the trust itself collects the income and has to report the income at the highest marginal individual income tax rates. And I believe, and you probably know better because you do returns, I think it's around 40%, 39.6.
Yes.
Plus there could be additional taxes, federal, for example. There's also state rates. And so the effective overall rate could be up around 50%. Whereas individuals that file on the same income don't really pay those really high rates till their income gets, over $400,000. I think it's about $450,000, $456,000, $457,000 for a married couple. So you're looking at a lot more tax being paid by a trust. So if you have a trust that has to actually pay its income tax, it could pay a lot more taxes than if, for example, mom was able to take that income and just pay it on her return, especially if she's retired. So yeah.
Related to this, then, we got this 39.6% tax rate as the maximum tax rate. It applies for trusts when their taxable income exceeds $12,150 for 2014. It'll index slightly higher for 2015.
Right.
And then in addition, we've got this net investment income tax. It's the 3.8% tax on net investment income.
Right.
And most income of trusts is net investment income.
Right.
So we're throwing that on top of this 39.6, and that's a really significant tax increase for trusts. In addition, if you have long-term capital gains, now one thing about trusts, in most cases you can distribute that income out to the beneficiaries. You can do some planning,
right.
And if that income is distributed, it's subtracted from the taxable income. But most of that doesn't apply to capital gains. And so for long-term capital gains, remember before this tax law change, the maximum rate was 15%.
Mm-hmm.
Now the maximum rate is 20% when your income for the trust exceeds that $12,000.
Right.
And then you throw on top the 3.8, so we've gone from 15% to 23.8%.
That's right.
It's really, like I say, trusts have been whacked.
They have been whacked, I agree.
So these are things that are really affecting our thinking.
Yeah.
And some people are thinking about, well, should I even be keeping this trust and so forth. So anyway, so let's talk a little bit around this then. I mean, a lot of these trusts were created really, like you said, they were bypass trusts. The idea was to use that exemption. Now we know that we can get the exemption even if we don't have the trust. So maybe, let's talk a little bit about some of the thinking related to what's going on and looking at these trusts again.
Well, on the one side, some families may say that trust really should go away. That, we'll say again, mom as a surviving spouse really should pull the assets out into her estate. It'd be great tax planning for the family, get step up in basis. And you can also save compliance costs, having to pay, sorry Michael, putting you out of business here as the return preparer. There's ongoing costs of compliance and all those things. On the other hand, there's often some really good reasons that may be non-tax reasons even for keeping those trusts in place. Like I mentioned at the beginning, if there is a second marriage and there are children from a first marriage and you want to make sure that those children are going to receive their inheritance eventually, if it goes to their stepmom, they may never see it. So there's also creditor protection, protection from divorce or getting the surviving spouse getting remarried and giving things away. And there's all kinds of reasons why someone might still set up an AB or ABC, something with a bypass trust.
Right. So there's a couple of things to think about here. Like you said, there are a lot of non-tax considerations, but one is just, what if something happens to both of them? What if they both go down in that airplane, I hate to say it, or in an auto accident.
Yeah.
So we hate to throw out that piece of reality, but sometimes these things happen. And so then these trusts become very helpful for the families, and also particularly for managing the property, and especially for minor children.
Right. So you definitely don't want to obviously get rid of a trust where there's minor children or children that are disabled. And again, a lot of folks come in and they are concerned because their children are teenagers, young adults, and they're not sure if they're going to be responsible or make a good choice in a marriage. And those are reasons to maybe keep the assets in trust. We see more and more families wanting to keep trusts set up for the children for a lifetime, because of the creditor protection and just being able to have that fund there that they know can be preserved for capital for the child. But there are also tax reasons, because if a trust, for example, is set up for a child's lifetime, it can be set up so it skips that child's estate for death tax purposes. So if that child becomes a very successful entrepreneur or has a lot of stock from a high-tech company, those assets can then eventually skip to their children without any death tax. And again, the death tax at 40% is federal. There's no California death tax, but it's a hefty tax.
And we talked a little bit about generation skipping taxes, but now, and you talked about basis and so forth, so let me just throw this out. So the trust doesn't really even have to be a bypass type trust.
True.
It can have what we call a Q-tip type trust. So,
right.
In other words, what's happened is that the decedent, if you will, deceased spouse, he still gets, or she gets to direct where those assets are ultimately going to go.
Right.
The surviving spouse elects to include those assets in his or her estate. Now, those assets will get the basis adjustment that we talked about. The income is going to pass through to the surviving spouse. And again, we know that those assets are ultimately going to go to the children, usually of that marriage, of that husband and wife. So anyway, so there's other trust planning that's not just the traditional. It just means that now we're going to be thinking a little bit differently about how we use these things.
We definitely do, and that could be the best of both worlds. Take your bypass trust and make it what's called Q-tipable, meaning the surviving spouse can elect to get it into their estate for basis step up, but keep it out of the estate for creditor protection and to make sure the kids' interests are secured. The only issue with that, of course, is do we have a crystal ball? Do we know that Congress won't raise those tax rates again? Because remember, once we elect to include it in the survivor's estate, it's in the survivor's estate, and if the exemption doesn't stay over $5 million, if it goes back down to $1, $2, $3 million, then the family might end up paying death taxes that they might not have had to pay.
Okay, there's one other thing I want to mention. So we were talking about the generation skipping. So you can elect to treat it as a taxable transfer for generation skipping. In other words, you can use the deceased spouse's generation skipping exemption for the Q-tip trust, even though it's not subject to the regular estate tax. So, folks, I hope we're getting the idea about, wow, maybe I really do need to see an attorney and talk about this stuff.
Well, there are a lot of things to think about, that's for sure. So, and the generation skipping exemption being as high as the estate tax is wonderful. So, passing it down multiple generations is incredible. There's a lot of ways to leverage that and make it more if you happen to have those kind of assets and want to do that kind of planning.
Okay.
So.
Now, let's say somebody does decide, okay, we fought through everything, and we think that it's best to terminate this trust. Does the family have to go to court in order to terminate this trust?
Maybe or maybe not. So if everyone's still alive, mom and dad are the settlors or grantors, that's what they're called, people who set the trust up. If they're still alive and all the beneficiaries are alive and they're adults and everybody consents, they can terminate the trust under a provision of the probate code by a writing. But everyone has to consent. If there are minor beneficiaries, one of the settlors or one of the beneficiaries is deceased, there's something like that happens, then you do have to go to court and petition. But if you have a good reason for it, and usually if you're petitioning to terminate a trust, there is a good reason for it. There's a family reason, or the trust is so small it's just not economical to keep it together. There's changed circumstances. I've had situations where a trust was supposed to be held just because they thought there might be death taxes and audits and things, but none of that happened because the exemption went up. So there was no reason to keep the trust in existence for several more years. There's just so many reasons. And so it's a good idea at that point then to go in, as long as everyone consents. If someone objects, all bets are off because the court is not going to approve terminating the trust if someone's going to object to that or think there's a good reason to keep it.
Okay.
So.
But the thing is that some trusts that in the past we may have thought were economical to preserve,
Right.
with the changes in the law that have happened and so forth, maybe they're uneconomical now.
Right.
And so there may be a reason, again, that's acceptable to everybody
Definitely.
to go ahead.
Yes.
Yeah.
And usually if there aren't good reasons to keep the trust in place, everyone will agree to let the trust go. But in any event, even if an example where we have a bypass trust and the surviving spouse has a ability to withdraw principal, just based on support, health care, that sort of thing, it's always a good idea to get all the beneficiaries' consents in writing, even if you don't have to actually go to court to terminate it, because sometimes the trust terms themselves allow the surviving spouse to withdraw up to the whole principal. And that might be a good idea to pull those assets into the survivor's estate. But the kids really do need to consent, because if the surviving spouse takes those assets and gives them away, you want everybody to understand that there are some risks involved.
Right.
So
one thing, Jennifer, you and I are in California. In California, we're lucky in some ways that our inheritance tax was repealed years ago, and basically there's a constitutional provision that says we can't have an estate tax.
Right.
And so with that, that's not a concern, but in other states, they do have state inheritance taxes, and so that may be a consideration in this plan.
They do. So, and it depends, where you own property, and I don't know the list of all the states that have inheritance taxes, but in some states it's fairly large, and it's in addition to the federal estate tax. Some states, we used to have what was called a pickup tax, so it just took a portion of the federal tax, but some states have actually additional inheritance taxes. And so it's always good to get advice in each state where you own real estate or have assets, and find out what the rules are going to be for transferring those assets, and making sure they're in a trust to avoid probate, so you don't have probates running in 4 or 5 different jurisdictions where you own little lots of property and things.
Right.
Right.
So I think we're close to out of time here. Yes. So I guess what I'm going to do is just sort of sum it up and say, folks, this is a complicated area, and this is not a do-it-yourself job. That's part of the reason for my having Jennifer here to talk to us about it today. You really do need to have a team of people that you're working with, sort of to think around the edges of this problem. In some cases, this means family meetings and things like that in order to hash through these issues. We hope we've given you something, again, for the beginning of a conversation with your own advisors. We'll see you next time on Financial Insider Weekly.